Hello, everybody, and welcome to today's webinar. My name is Paula Price. I'm with the People's Law School, and I will be your host and moderator today. Today's webinar is Estate Planning in BC, Planning Outside of a Will. And we have an amazing guest speaker, lawyer Julia Norman, who I will be introducing in just a few minutes, who will be answering all our questions about planning outside of a will. So today, of course, we are talking about planning, and the type of questions that we will be addressing are what is and is not included in a will. We will talk about the pros and cons of jointly held property, designated accounts, and trusts. We will be talking about cost and tax efficient planning. Now, what you can expect to see over the next 60 minutes is answers to questions. And what we are sharing is legal information, which is distinct from legal advice. Legal information, the difference being for legal advice, what we would be doing would be looking at the law as it applies to your unique set of circumstances. And if that's what you're seeking, then we would encourage you to reach out to a lawyer. You're welcome to reach out to our speaker today, Julia Norman. Her contact information is on the screen. And of course, the information that we are sharing is current as of today. We would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody who is joining us here today to reflect upon where it is that they are joining us from. We would like to acknowledge and thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation of British Columbia, whose financial support makes production of our webinars possible. And finally, we would love to thank and welcome our guest speaker today, Julia Norman. Julia is a lawyer with Pusher Mitchell in Kelowna. Now, Julia's practice is in estate and trust planning, and she's got a wonderful diversity in her practice. She has about 1/3 in the planning area, what we're talking about today, about 1/3 in administration, so administering an estate after somebody passes away. And she also has about 1/3 of her practice in estate litigation, so disputes that arise after somebody has passed away. And so Julia brings a wonderful perspective to the questions that we are addressing today. Julia is also a member of the Society of Trust and Estate Practitioners, also known as STEP. Julia, thank you so much for joining us today and welcome.
Thank you so much, Paula. It's fun to be here. I'm excited to be a part of this webinar.
Amazing. And we are so delighted to have you here today. So we're going to dive in with the questions. And this first question really does set up the whole premise. What assets are included and not included in a will? And which assets will go through probate?
Absolutely. So before I get started, thanks again for having me. I just want to echo what Paula said, that this really isn't intended to be legal advice. It's legal information only. And estate planning is highly fact dependent, and many of these questions are very narrow in scope. So I'm going to do my best to give you some information and some things to consider, but by no means is it a comprehensive or exhaustive list of all of the options or the considerations. So depending on your circumstances, I highly recommend, if you need help with an estate plan, that you do reach out to a lawyer. So with that being said, what assets are included in a will and not included in a will? So a will should actually be drafted broadly enough to include all of your assets, because your assets are going to change over time. What you have today might not be what you have in 5 years. And sometimes it's not practical to change your will every time your assets change. Before I get into probate is going to be a word that you hear a lot today, and I thought I would just provide a basic definition of what probate is as a starting point. So probate is a legal process where a court authenticates the validity of a will, and they provide the executor or the administrator the power to administer the will and to carry out the testator or the will maker's intentions. Whatever assets go through probate, and this will be a big topic in the questions today, but whatever assets go through probate and through that process are subject to fees of 1.4%. So that's $14,000 per million. You will note, and a lot of people maybe are here today to figure out how they can avoid probate fees. And one thing that I really want to point out and emphasize throughout this presentation is that sometimes it's actually, we are better off to pay the 1.4% in probate fees. I see this all the time in my practice where people go to great lengths to avoid probate fees, but then there's actually a lot of unintended consequences, and they can actually be far more expensive than that 1.4%. So I'll just use that as a little bit of a backdrop. So to get back to the question, what assets are subject to probate then, and what assets pass through a will? So as I said before, all assets will pass through probate with the exception of, and there's sort of three categories. Jointly owned property. So that's, for example, a house that's owned in joint tenancy. Maybe you own a house with your spouse. That will not go through probate because that will pass to the other surviving joint tenant. And that includes other personal property, bank accounts and things as well that are owned jointly. Assets with a designated beneficiary. So there's registered investments that include TFSAs, RSPs, and RRIFs, depending on how old you are. Those do not pass through your estate and are not subject to probate fees if they pass to a beneficiary. Same with life insurance and sometimes employer pensions. So I'll classify those as assets with a beneficiary. And the third category is property that's held by a trust. So sometimes when we move property into a trust during your lifetime, those do not go through your will and they therefore do not go through probate. I think that's all I have for that question, Paula.
Excellent. Thank you so much, Julia. Here's a question. Going back to the will, I prepaid the expenses related to my funeral. So cremation, plot, funeral. Do I need to include this in my will?
Yeah, it's a good question. Not necessarily. I do recommend to my clients that if you know what you want and you have specific wishes, that you do put it in your will. Having said that, oftentimes I do a lot of administration as well, as Paula mentioned, and practically speaking, if somebody passes away on a Friday or on a weekend or a holiday and the will is at the lawyer's office, sometimes the executor doesn't actually get the will until after they've started making funeral arrangements. So what I really recommend is that you let your executor know of your wishes so that there's no doubt as to what you want if something happens to you. But yes, I do recommend also putting it in the will, although it does not have to be there. It's not a legal requirement.
Excellent. Thank you. And so moving to the next question, what are the pros and cons? You mentioned designated beneficiaries as being one of the ways or one of the areas that will not be included inside of a will. What are the pros and cons of designated beneficiaries from a planning perspective?
Absolutely. So again, as a reminder, designated beneficiaries can be put on registered investments. So we have registered and non-registered investments. Registered investments include TFSAs, RSPs, and RRIFs, typically, and life insurance. You can also have a beneficiary or a beneficiary on life insurance. So again, this is certainly not an exhaustive list, but there's many pros and many cons. In terms of the advantages, there's no probate fees. So that's what we talked about in our first question. So anything where there's a designated beneficiary, it passes outside of the estate, we save that 1.4%. So if you have a RRIF with $500,000 in it, we're going to save $7,000 in probate fees. So that's one advantage. Another advantage is it's private. So probate is a public process. Any court document is public. So by not going through probate or by not having an asset pass through probate, it's private. And there's a quick payout. So financial institutions, usually upon death, and when they receive a death certificate, they will pay out the registered investment quite quickly and send it right. So you're not waiting for probate, because probate can be a very time consuming and slow process. So speed is another advantage. In terms of the cons, Typically speaking, beneficiaries that receive something through as a designated beneficiary will receive it without a trust. So this means it's going to them directly. This can be highly problematic for minors. So I absolutely don't recommend naming a minor on any sort of as any sort of beneficiary. And I see this commonly, this is a common mistake that people make. I do not recommend naming any sort of disabled individuals that are receiving persons with disability benefits or funding, or if there's some sort of, spendthrift individual or somebody that needs a trust in place. It's a very difficult way to give someone funds through a beneficiary designation. So those are a few disadvantages. Another disadvantage is you can inadvertently cut out a beneficiary. So what happens is if you have, for example, your two children as beneficiaries of your TFSA and one child dies, it'll all just get paid to the surviving child unless you can change the beneficiary designation. And you can, of course, only change the designation if you have capacity. So sometimes in your will, we might say if you lose a child, that their portion will go to their grandchildren. So it'll sort of flow through the family. That's not how it works with designated beneficiaries. It just goes to whoever else you have listed. Another significant disadvantage is tax liability. So we really need to watch where does the tax liability fall? So as you probably know, with an RSP or a RRIF, there's a significant tax liability on death. That tax liability falls to the estate. So the estate pays the tax on the RRIF or the RSP. But if you have a different beneficiaries under your estate as opposed to your RRIF or RSP in this example, one person, you might have intended for them to get money through the will, but now they're paying the tax of the beneficiary under the RRIF or the RSP. So we just really need to be mindful of where do the tax liabilities fall and who are going to pay, what individuals will pay the taxes. That matters a lot less, of course, where the beneficiaries are identical. So if you're giving everything to your spouse under the will and everything to your spouse under the beneficiary, then it matters less, of course, because the beneficiaries are the same. Now, where nobody is named as a beneficiary, the estate is the default. So if you have nobody listed on your TFSA, the TFSA will be paid to your estate. It will flow through your will, and then we'll have the probate fees of 1.4%. And as I mentioned, sometimes this is actually a good thing. Sometimes 1.4% is actually not very much to ensure that the assets pass through the will. And if you have a will with trusts that will satisfy your needs and help to care for the people that you want to provide for your beneficiaries, it can be actually highly advantageous to have those assets passing through your will and into the appropriate trusts. One other thing that I'll mention quickly is it is possible to do what we call a life insurance trust declaration or a registered investment trust. Now, what this is it's actually very complicated and fairly sophisticated planning, but a lawyer can create a life insurance trust declaration. They can provide it to the insurer so that instead of it passing through your will, it passes through that sort of separate trust that's attached to your life insurance policy. As I mentioned, it's fairly sophisticated planning, so this isn't something we would do commonly, but it is an option. For example, if you have a large life insurance policy and you want to save those probate fees, but you also need the trusts.
Excellent. Thank you so much, Julia. It's so interesting to learn all the different pros and cons of the beneficiary designations. Much appreciated. Here's a specific question about a life insurance policy where you'd like to remove one of the designated beneficiaries. Is that something that you can do by updating your will, or do you need to go back to the policy itself?
Yeah, that's really important to go back to the insurer. Or you can create that life insurance trust declaration that I just mentioned. But even where we as lawyers help clients to do these life insurance trust declarations, we have to send them to the insurer so they attach to the policy. So that's really, really important. You could have the best will and the most comprehensive, well thought out will with the best trusts. But if you don't have if assets are held in a way that don't flow through your will, we can defeat the intentions of what would otherwise be a really good will. So it's really important, and we'll talk more about property ownership in a few minutes, but it's really important to think about who owns the property. Is it going to pass to a designated beneficiary? Is it going to pass by the right of survivorship? Because like I said, we can have a great will, but the will is only effective if the assets pass through it.
Excellent. Thank you. Here's another question. I don't have a spouse or children. What is the best way, from a tax perspective, to dispose of my registered retirement income fund and tax-free savings account?
I mean, you can give your RRIF or your TFSA to whoever you want. So if there's another friend or a distant family member or somebody that you want to provide these investments for, you absolutely can. There would be no other real tax. I think what this person may be getting at is sometimes when you provide for a spouse, there's a spousal rollover, so it doesn't trigger the tax on the RRIF. Of course, there's no tax on TFSAs in any event, but you can roll over the RRIF to a spouse without triggering the tax, and then the tax would be triggered on the death of the spouse. So that may be the question here. So whoever you give the asset to, the RRIF to, there's going to be a tax liability. Now, if you have sort of philanthropic goals or wishes, you can give the TFSA or a RRIF to a registered charity, and you will receive a donation tax credit in your estate, which would help to offset some of that tax. So that's another option if you're looking for those tax advantages.
Super. Thank you, Julia. In this example, so for my registered retirement savings plan and tax-free savings account, do I need to name beneficiaries that live inside of Canada and are Canadian?
The short answer is no, you can give to an American, although cross-border planning is highly complicated. So wherever there's a cross-border issue, I would highly recommend getting accounting advice, particularly cross-border accounting advice. And this is for obviously beneficiaries, but also if you've got, like I highly advise against having, for example, an American or not even just a non-Canadian resident as an executor of a will or a power of attorney, because there is a lot of unintended tax consequences. So really, I think the upshot of this is wherever there are non-residents, it's important to get the appropriate tax advice.
Excellent. Thank you, Julia. This next question, now we're moving more into the questions about ownership and joint ownership of property. I'm getting older. It would be convenient to add one of my children to my bank account. What are the pros and cons?
Yeah, so one or more people can hold property together. And this is generally a structure called joint tenancy. And we talked a little bit about this earlier. So where one person passes away, the asset passes by the right of survivorship to the other person. So it reverts to the survivor. And this can be applicable for real property and personal property. So for things like bank accounts, in addition to actual real property. And we'll talk about real property a little bit more in a few minutes. So this is similar to registered investments and life insurance that pass outside of a state, in that there's advantages for sure, but there's a lot of disadvantages that I think are very important to consider. So the advantages are very similar to what we discussed before. So there's no probate fees when something passes by the right of survivorship, and it's fairly easy to administer. So often no probate is required. If you own everything jointly with your spouse, you pass away, everything passes by the right of survivorship to your spouse, there's no probate. In terms of disadvantages, there's often unintended consequences. So it's really important for somebody doing their estate planning to consider what their intentions are. There's something at law called a presumption of resulting trust. And really what this means is where a parent holds an asset with an adult child, there's a presumption that that adult child is holding that interest in the asset for the benefit of their parent or their parent's estate. I'll just break that down and give you a bit of an example. So where an individual, say you have a bank account with your parents, say there's $50,000 in that bank account, you were on that bank account jointly with your parent. There's a presumption at law that that is not your money, that that is your parents' money, and you were on there for the purpose of convenience only. Now, it's really important to document this intention because sometimes parents, that's not their intention. They want the $50,000 to go to their child when they die, but there might be 3 other kids. So that is a huge part of my litigation practice where people start adding their kids to assets, but the intent isn't clear. Are they wanting the assets to actually pass to the children? Or are they just on there for convenience purposes? Sometimes it can be in the opposite direction where a child may need their parent on to help qualify for financing. That doesn't mean that it's their parents' home. It means that their parents help them finance a home and they're on for the purposes of convenience. So that's what that arrangement called is it's called a bare trust arrangement. And it's really, really important that that's very well documented so that when you do pass away, it's very clear about whether you want the property to be an estate asset that's divided through your will and the beneficiaries, or you want that asset to pass outside of your estate. I did mention a bare trust. That's a bit of a buzzword, but you may have heard all of the news articles in the last couple of years about the filing requirements, the tax filing requirements that the CRA imposed for bare trusts. It caused a lot of chaos last year until the CRA said that we didn't need to do it this year. Now, there is draft legislation right now that says that we do have to file for bare trusts. So, and there are a bunch of exemptions. So again, I'm not going to discuss particular circumstances, but the bottom line is where you hold an asset with your parent or with your child, there may be a bare trust arrangement that needs to be disclosed to the CRA and a tax filing needs to be done. And a lot of people don't realize that. So that's certainly a disadvantage because it's expensive and time consuming to do tax filings every year for a bare trust. Another significant disadvantage can be capital gains. So if you own an investment that's increasing in value with your child or with your parent, whose investment is it again, and who's responsible for the tax liability associated with that investment? And those are just a few of the disadvantages. We'll get into a few more when we're talking about property.
Excellent. Thank you so much, Julia. This next question is about joint tenancy-in-common. What is the difference between owning your home in a joint tenancy versus tenancy-in-common? How would it affect my will?
So joint tenancy, again, passes by the right of survivorship. So when one person passes away, the entire property becomes the survivor's property. And I'm using the example where there's only 2 people. There could be 3 or 4 people where this would occur as well. So say 2 parents and their child own a house together, both parents pass away. And, if intent is clearly documented, then it passes to the child. Or if there's only 2 people, that passes to the survivor. Tenants-in-common means there's actually on title to the property, it actually shows up as a specific interest. So if you own the property 50-50, your 50%, if it's owned as tenants-in-common, will pass through your will. So it's subject to probate, it's subject to the 1.4%, but then it goes to your beneficiaries. It doesn't automatically go to the other person that's on title. So this is very common in second relationships and blended families, because oftentimes somebody may not want their new spouse, for example, to get their half of the property. They may want their children to get their half of the property. So the other thing that's really important to consider here, where there's a tenants-in-common arrangement, so again, that could be 50-50, it could be 90-10, but your ownership passes through your estate. it's important to consider whether the other person on title should be allowed to continue to live at the property after your death. So again, I mentioned blended family situations. If tenants in common is agreed upon, and that's what people want to do, which honestly is generally recommended depending on the situation. You may want your spouse to be able to stay at the property after your death. So that also needs to be outlined in your will to make sure that then your beneficiaries aren't compelling the sale of the property, because you may want your spouse to be able to continue to live there for many years.
Excellent. Thank you so much, Julia. This next question, my spouse and I own our house as tenants in common. Will it need to go through probate when one of us dies?
Yeah. And sorry, I probably got a little bit ahead of myself and answered that already. So of course the answer is yes. So one spouse passes away and it's owned as tenants in common, their portion goes through probate. It's subject to the 1.4%. But again, and we consider what I had mentioned earlier about allowing your spouse to stay. It's called a life estate. So we can give your spouse a life estate and say, look, you can stay in the property for 2 years, for example. And then the property will be sold and my portion will go to my children.
Excellent.
One thing that I think is really important to mention, Paula, that we haven't talked about yet, and I'm sure you've talked about this in your last webinar, but it's wills variation claims. And I think wills variation claims are highly relevant to the topic today. So for anybody that doesn't know what that is, in British Columbia, we have a legal and a moral obligation to provide for our spouse and for our children. And I think that surprises a lot of people because a lot of people don't realize or recognize that we do have an obligation to provide for our children. So for example, where you own all of your assets, and this is typically more of an issue in blended families, but where you own all of your assets with a spouse, if you die and everything's owned as joint tenants, it will automatically all go to your spouse. That means that your child has nothing to challenge because there's nothing going through your will. It all goes to your spouse. When your spouse dies, if they're not the parent to your children can't challenge their will. So if that spouse repartners, or if they change their will for whatever reason, maybe they don't have a great relationship with your children, they have no obligation to provide for your children, and your children have no recourse as against your second spouse. So that's why it's really important to consider how your assets are going to pass, whether they're going to pass jointly, whether your kids would have recourse as against your spouse to challenge their will. Anyway, I think that's just very relevant in the discussion today.
Excellent. Thank you so much, Julia. It is relevant. And we do have a webinar coming up on December 10th, where we will be talking about contesting estates and wills variation challenges. But very much appreciate that additional insight and perspective. I figure I have another 5 to 20 years left to live, and I want to stay in my house as long as possible. What are the pros and cons of adding my daughter to the title?
But I think these are the sort of similar advantages and disadvantages that we've talked about above. I would recommend this in very, very narrow circumstances. I get asked all the time about adding your child to title, and my sort of standard answer is I do not recommend it. There's a lot of I'll quickly go through the advantages, which are the same as before. It passes by the right of survivorship. There's no probate fees. The risks are significant though. So capital gains, I alluded to that earlier, but we have where it's your principal residence, the increase in value is tax sheltered. We do not pay in British Columbia any tax on the increase of value of our principal residence. It is possible that if you add your child to title and they have a principal residence elsewhere, that you may lose that principal residence exemption and you may end up paying capital gains, or your child may end up paying capital gains on the increase in value of your house, which is a very significant problem. There's also property transfer tax to consider. So sometimes there's limited exceptions where you can add a child and not pay property transfer tax, but property transfer tax typically is far more than probate fees, and you can inadvertently trigger property transfer tax. Speculation tax needs to be considered. There's your children's creditors. So if they get in an accident or if they're sued and they're liable, all of a sudden you could have a creditor coming after your property. Same thing if your child was to separate from a spouse, you could have their spouse coming after your property. And again, there may be defenses to these types of claims depending on what the intention or the arrangement is. Is there a bare trust arrangement? Why are they on title? But typically it's not something that should be done without very good legal advice and significant consideration of the possible risks.
Thank you so much, Julia. Really, really helpful. Um, Moving on to the next question then. My brother and I are on title of our dad's house. Neither of us lives there. We've been told that when my dad passes away, we'll need to pay a significant capital gains tax because it's not exempt as our principal residence. Is there anything that we can do to avoid triggering the tax?
I mean, if it's not your principal residence and you're both claiming the principal residence on other properties, the principal residence exemption that is, then no, you're going to have to pay the tax. Having said that, you can the definition of a principal residence in the Income Tax Act is actually fairly broad. So if you own two properties, it's often worth doing some sort of pro forma calculation with your accountant to determine which property should be your principal residence. Obviously, you have to satisfy the definition of principal residence, but like I said, it actually is a fairly broad definition. But if you don't live there and you both have other properties, then you're not going to be able to claim the principal residence exemption, and there's going to be capital gains tax payable on the increase in value.
Super. Thank you, Julia. Moving on to our next question, another one of the areas that we talked about. So there were the designated beneficiaries, joint ownership of property, and then trusts. So what kind of trusts are available? When does it make sense to use them? And is it more cost effective to put your assets in a trust instead of the will?
Yeah. So there's two categories of trust. Trusts are very complicated, and there's hundreds of different types of trusts, but there's two categories that I'm going to talk about today. The first is called a testamentary trust. So this is a trust that is created on death. It's usually a trust in your will. Many of you, if you have a will probably see these trusts. So they can include trusts for minors, which we see a lot. Spouses, so a spousal trust, maybe in that blended family situation to preserve capital for your ultimate beneficiaries. Maybe a testamentary trust is used for persons with disabilities, spendthrift individuals. There's numerous reasons for a testamentary trust. The minor trust, as I mentioned, is probably most frequently used. We use that all very, very, very often. And the reason we do this is because we can control the timing of the distribution of an inheritance. So in BC, you don't reach the age of majority until 19, but many people still feel like that a 19-year-old receiving significant funds from an estate or through a will is too young. So you may create a trust to age 25 or age 30 or whatever you feel is appropriate for your children or your grandchildren, or your great grandchildren, whoever you may be giving to, or nieces or nephews, or I mean, honestly, it could be any minor. So the trustee can also control what the funds are used for. So you may put in the trust that you want the trustee to be able to encroach on capital of the trust for educational purposes before the beneficiary is 25. Something like that is entirely reasonable, and is done often. The second category of trust is called an inter vivos trust. So this is a trust that's created during your lifetime. This is used in more limited circumstances than a testamentary trust, but can be a very effective estate planning tool. You may have heard of an alter ego trust or a joint partner trust. Those are types of inter vivos trusts. And the really great thing about those is once you reach age 65, you can transfer your assets, some assets. I won't get into the complexities, but some assets are better suited to those trusts than others. But you can transfer those assets into an alter ego, or a joint partner trust without triggering the capital gains tax, because no one wants to get a big tax bill where you don't have to. So again, those kind of inter vivos trusts, and there are other types of inter vivos trusts besides the alter ego and joint partner, but they can be used for tax and probate fee planning. And the other reason that we see them very commonly is for wills variation planning. So if, for example, if you are trying to disinherit a child, you may want to move your assets into an inter vivos trust, for example, an alter ego or a joint partner trust, so that those assets do not pass through your will. They pass outside of your will, and then they're not subject to challenge ultimately by your child or your spouse or whoever you're not providing for. Maybe if I have just a quick second more here, I think one disadvantage to inter vivos trusts is they can be quite expensive to set up. And they do require those ongoing tax returns yearly. And then again, as mentioned, depending on what kind of inter vivos trust, there can be tax consequences when we put the assets into the trust. So I'll leave it there.
Excellent. Yeah. And thank you, Julie. You answered the question I was about to ask you, which is that cost-effective aspect of it. When is it more cost-effective to have those assets go in the trust versus a will?
Yeah. I mean, typically speaking, unless there's another reason to do it, it's not something that's commonly done. Like I said, unless there's significant assets and there'll be very significant probate fee savings or for wills variation purposes. And that's those inter vivos trusts. Like I said, a testamentary trust, which we talked about at the beginning, they're done, I would say, in probably 90% of all wills that I draft, because usually there's some minor, whether that's a child, a grandchild, a great grandchild, a niece, a nephew.
Excellent. Thank you. So if you are to create a trust, what types of conditions could you put on assets held in trust for a family member?
Trusts are highly customizable. So you can determine who looks after the funds. So you can pick who the trustee is going to be, or trustees. Maybe it's even a corporate trustee. Most of the big banks have trust services. You can control when the person gets the funds, how much they get, the frequency, the duration, how the funds are used, what they're used for. So their trusts are highly customizable to suit the needs of the person creating it and the beneficiaries.
Excellent. Thank you. One last question, and then we're going to turn to the live questions that have come in today. In this example, my niece has Down syndrome. I want to leave her money when I die. I've been told that she might be disqualified from other means of support if she receives extra money. Would a trust be a viable option? Where would I go for more information?
Yeah, I think this is really important. So I'm glad that somebody asked this. So a person receiving Persons with Disability Funding, we call it PWD in BC, they have an asset limit and an income limit, which means if they have over a certain amount of assets or over a certain income threshold, they are subject to lose that funding or those benefits. And that's certainly something that we want to try to avoid. So there's certain types of trusts, and it's important that the beneficiary is in BC, because if the beneficiary of the trust is somewhere else, the rules are not the same. But in BC, if we're providing for someone who receives PWD, so for example, this niece with Down syndrome, we can create certain types of trusts that don't contribute to that asset limit. So right now, the asset limit is $100,000. If you were to give your niece $200,000, but it's in a specific trust, we call them Henson trusts, it doesn't count toward that asset limit, which is really important so that they can continue to receive their ongoing funding. There is more information on the government website. So I just looked ahead of time, and it's called the Disability Assistant and Trust booklet on the government website, and that's fairly helpful. And the legislation is called the BC Employment and Assistance Legislation. So that's another resource to look there. But it is very important where you're giving to somebody who's receiving PWD to consider these types of trusts.
Excellent. Thank you. So Julia, turning to the live questions, and thank you everybody for your questions. These are excellent. I'm going to start with this one. If there is no spouse or dependent children, where can the executor free up funds for ongoing, and then in brackets, non-funeral related expenses while awaiting probate?
Yeah, it's a very good question. So what would happen is if the person has a will and you are the executor, and that person has liquid assets, so there's liquidity in the estate, you can go to the bank, give them the funeral costs, and the bank will give you it. They will release the funds ahead of probate to pay for funeral expenses. So that's if there's no liquidity, that becomes a far more difficult situation. So if say there's just a house, for example, you can't sell the house till you have probate, you have no money. So there's a number of things you can do. You could pay for it yourself to be reimbursed. You could do a cash call to the beneficiaries and see if one of the beneficiaries are willing to pay, or ultimately then if that's not possible, you're looking to some sort of government organization to subsidize those funeral costs and until there's liquidity in the estate.
Excellent. Thank you. Here's another question. We have a property and our son has built a house on our property. We have 3 other adult offspring who are not happy about the idea of him continuing to live in his house on the land. Is there a way we can guarantee his occupation of the land and make it fair to the others?
Yeah, that's a very difficult question, and it's something that I run into in my estate planning practice. I think there's a lot of considerations, and this is something that would a problem that really warrants discussion because, as I mentioned before, there's this wills variation legislation that allows the other kids. So, say if you were to provide the whole property to your son, your other kids could challenge it if there wasn't sufficient funds to equalize all of the children. And I think often there's not because our properties are our biggest assets. So we can't, if we have a property worth $1 million and there's 4 kids, oftentimes there's not $4 million to equalize that gift among everybody. So there are things that you can do. I think typically speaking, or maybe not typically, but often in your will, you could have a provision that would allow him the first right of refusal to buy your portion of the property at fair market value. But it also depends on how title is held. So questions that I would be asking are, how is title held? Did your son contribute to the property? Who paid for this second property that your son lives in? Maybe ownership of the property should be considered. So that's it. It's a complex question. I think that warrants discussion, but there's a lot of risk to that arrangement and potential unfairness between the other kids.
Excellent. Thank you, Julia. Here's a question. Once a RRIF goes through probate, is there tax on top of that?
Yes, absolutely. Yeah, it doesn't change anything. So if a RRIF goes through probate, so if you have no beneficiary, you pay your 1.4%, but the tax on the RRIF is the same as it would be otherwise. So the tax liability always falls to the estate if there's funds in the estate. If there's not funds to the estate, the CRA will trace where it went, where the funds went, and they will come after the tax from the recipient of the RRIF. So whether it passes as through a beneficiary designation or through the estate, the only difference is that 1.4% in probate fees. Otherwise, taxes payable either way.
Excellent. Thank you. I've read that if you gift money to one of your children and don't document it as a gift, it becomes a receivable to the estate. Is that true?
No, not necessarily. I don't think it's a fair statement to say that it becomes a receivable to the estate, but I do think it's important to document that. Another place where we see an issue between gifts and loans a lot is family law litigation. So if your child was to separate from their spouse, there could be an argument of whether that's a gift or a loan. Does it have to be paid back out of the joint property or not? So certainly I think documenting intention is very important. But no, it doesn't automatically become a receivable to the estate.
Thank you. So here's a question. In what scenario would the family home need to go through probate? A friend has said this is happening to her sister-in-law, both Wendy and her husband were on title, nobody else?
So that would be if they held the property as tenants in common. So there's two types of ownership that we talked about. Joint tenants. So if one person passes away, they gift the right of survivorship and the whole property goes to the other person. If you own as tenants in common, maybe they own it 50-50. We'll use those numbers for ease. Then I think the name was Wendy. Wendy's portion would go through probate and her 50% would be subject to the 1.4% and go to the beneficiaries in her will. So if the beneficiary is her husband or her partner, it would still go to her partner. If not, if the beneficiaries were, Wendy's friend, then Wendy's half of the house would go to Wendy's friends, not to her partner.
Excellent. Thank you so much, Julia. Here's another question. I've heard that a joint account that is not joint with either a legal spouse or a dependent child now becomes part of the estate of the deceased person. Is this true?
Maybe. A lot of this is based on the intention. So there was the presumption of a resulting trust that I mentioned earlier, where there's a presumption that if an adult child is on an account with their parent, that there's a presumption that that money does not go to the adult child. So there's a lot of litigation over this because everybody is trying to ascertain what the parent's intention was. Was the parent's intention to gift this money to their child? Or was it their intention that their child would help them pay bills? But it was the parents' money to be divisible to say all of the children. So I can't answer that definitively. It depends on the intentions, but what I will say is there's significant risk in an arrangement like that where where intention isn't very clearly documented.
Excellent. Thank you. Here's a question. Is a high interest savings account a registered account that can pass outside of the will via beneficiary designation?
No, it's not. No.
Okay. What if I gift everything to my children before I pass? No probate, no will, nothing. What is wrong with this too good to be true?
Well, that's absolutely fine. And certainly we are entitled to make inter vivos gifts. So that's gift during our lifetime. I think the issue with that is if you live for a significant portion of time after you've gifted away all of your funds, you have no control over your funds. So your funds are gone and you're relying entirely on your children to look after you.
Excellent. Thank you. Is a designated beneficiary in a non-registered account also not going to pass through probate, or is it only registered RSP or RSP, RIF, LIF, etc.?
Yeah, so we can't have designated beneficiaries on non-registered accounts. So we can only have beneficiaries on registered accounts.
Excellent. Here's a question. What to do for a house with an existing mortgage, but I want my children to have the house when I pass? Would it be easier on the part of my children if I just fully pay the mortgage, which I can now while I am still alive?
Yeah, I think that depends on several factors. Do you need the money? What is your interest rate? If you were to give the property through your will, we'll assume that you're not going to add your kids to title for all of the many reasons that we talked about earlier. But if through your will you're going to gift your property or the residue of your estate to your children, what would likely happen is they could continue to make your mortgage payments, the property would be sold, and then of course the bank or the financial institution that holds the mortgage would be paid out first, and then the net sale proceeds would be divided between your children or your beneficiaries. So I don't think there's a right or a wrong answer. It may be a little bit easier if there's not a mortgage because then they're not worrying about the liquidity to pay the mortgage. But it sounds like if you have the funds to pay the mortgage now, they wouldn't have a problem making those payments until the house sells.
Excellent. Thank you. And Julia, you're doing such a great job with all these questions. It's amazing. Thank you. Here's another one. My dad, and thank you everyone who's submitting questions. These are really, really
Yeah,
great questions.
they are good questions.
Excellent. My dad meant well by, and this is similar to one of the questions we addressed. My dad meant well by adding my brother and I to his house title for conscience reasons, However, my brother and I are now freaking out as we just learned that this may cause us to incur a huge capital gains bill because it is not our principal residence. My dad never intended for us to end up with a huge tax bill and now wants to undo that decision so we don't get a huge tax bill. Can he undo this?
Uh, yes, potentially he could undo it, but you've been moving forward. But if the property has already increased in value, if you've been on title for 10 years, you still have that 10-year period. That's a problem. So I think my answer would be go see a lawyer. This is something that I deal with in my practice often because people really believe often that adding their children to title to avoid that 1.4% is a good idea. And hopefully if there's one thing that I've been able that you can take away from this is that there's many considerations and it's not just probate fee savings. There's if you end up having to pay capital gains tax and speculation tax and property transfer tax, that is going to be so much worse than probate fees. So I guess in answer to your question, it's possible that you could document your intent. And if the intent the entire time was that this was your dad's property and you were on title for the purpose of convenience, it's possible to document that intent through what we would call a bare trust agreement. So that's something that could be documented and tax returns you would have to file tax returns for that and disclose that through the landowner transparency registry in British Columbia. But it's something that I would recommend that you seek legal advice on, but perhaps there is some planning depending on intent that may get you out of some significant capital gains.
Excellent. Thank you so much, Julia. And there is a question here. If somebody from Greater Vancouver would be able to avail of your services.
Yes, absolutely. Just send me an email.
Amazing. So here's another question. And again, I appreciate how many questions you're responding to. I really feel like I'm examining you like a law
Oh,
professor or something.
no problem. I like this.
Is the tax liability of the estate calculated before or after the probate fees?
It's before sorry, was the question is probate, sorry, can you just
I'll
repeat
read
that?
it again. Is the tax liability of the estate calculated before or after the probate fees?
It's before, yeah. So whatever, when you die, you're deemed to dispose of those assets at the date of death. So the tax liability would be calculated based on that amount. It's not like you can back out probate fees or anything like that first.
Okay.
But that's it. Probate fees are 1.4%. I mean, I really feel like a lot of clients get very concerned about probate fees and they're not insignificant, they're not nothing. But sometimes it's very worthwhile to pay the probate fees for all of the other advantages that we've discussed by having sophisticated trusts in your will and things like that.
Excellent. Here's another question. If a childless, spouseless person dies, parents are no longer alive, does notice of an application for probate need to be given to their siblings or only to siblings and all other descendants of parents?
I think this question is an intestacy question. So what the legislation says is that we have to provide notice of probate. This might be the first question that I can't 100% answer without looking at my rule
Yeah.
book. But
Yeah.
the short answer to this is that we have to provide notice to all intestate beneficiaries. So if those intestate beneficiaries, in your case, are siblings, yes, we have to provide notice to siblings. But in our rules, so in the Wills, Estate Succession Act, it's very clear about which descendants get notice. But I mean, I guess, yes, the answer to your question is if they would be intestate beneficiaries, so no spouse, no parents, no children, the next beneficiaries would be siblings and then nieces and nephews, and they would all have to get notice of the intention to probate. Having said that, keep in mind, we talked about wills variation legislation earlier. A sibling cannot make a claim to vary your will. So if you were of capacity and you weren't unduly influenced and you did a valid and binding will, they can't say, hey, you should have provided for me and you didn't, I'm going to challenge your will. They do not have standing to make that challenge.
Excellent. Thank you, Julia. And given the time, I think this is going to be our last question. And it's a bit of a recap on something you've already addressed in the course of the webinar. But would you remind us again, what is a bare trust?
Yeah, absolutely. So a bare trust is an arrangement where one person is holding an interest in some sort of property for the benefit of another person. So where we're seeing this often is bank accounts and properties where, for example, I think I'll use the child example because that's what we've discussed the most. You add your child to your bank account. Your child is now holding their interest in that bank account for you. So that's a bare trust arrangement. It's still your money during your lifetime. It's not your child's. They're on the purpose of that account for convenience or on the property for convenience. So that's a bare trust arrangement, and there are filing requirements, and that caused a lot of chaos, as I mentioned last year. But the CRA has really worked or the on trying to establish more clear guidelines for us moving forward. So we just need to make sure if that sounds like you could be in a bare trust arrangement, speak with your accountant before your next tax filings.
Amazing. Julia, thank you so much. Any final thoughts before we wrap up today about anything that maybe you reflected on during today's webinar or something you'd like to leave our guests with?
Yeah, no, thanks for having me. That was really fun. I just find this area of law so interesting. And I think because the facts are so varied, and you can see that even from some of the questions. So when we talked about intention and what is a will maker's intention, it's really varied, and people's reasons for having beneficiaries or not having beneficiaries or adding someone to title or not is different in all the circumstances. So I just would encourage everybody to really think through their plans, think through their wills, but also think through how their assets are held. And obviously it is complicated in blended family situations. And if anybody has any questions, I highly recommend obtaining legal advice in this area because it is quite complicated. And of course, we all want to leave our estates as tidy as possible for our beneficiaries after death.
Julia, again, can't thank you enough. It's been so informative having you here. I feel like I've learned a lot during this webinar. I need to go back and watch it again because you've really done such a great job of taking us through the other side of estate planning, right? What is not included in the will and the considerations that go into these different options, right? You know, talking about the probate fee, it being 1.4%. And so, yes, there is that cost, but then weighing that cost against your other options. And, you know, if you're saving that, what is it that you're trading it for? So I think you've done such a great job of painting that picture for us, and we're really grateful.
Thanks again, everybody. We'll have a great day. And thanks to the People's Law School for having me.
Well, thank you. And thank you, everybody, for joining us.